What is employment law? Employment law is the collection of laws and rules that regulate relationships between employers and employees. Employment laws say when an employer can hire employees and when the employees can work. The laws cover what an employer must pay the employee for their work. Following employment law, when an employer wants to hire someone, there is a lot they have to know. There are minimum wage laws that require the employer to pay a certain amount. There are laws that prohibit the employer from discriminating against applicants or employees based on certain characteristics. Employers must provide a safe working environment. In some cases, they must provide health insurance options. Employers must collect and submit payroll taxes on behalf of the employee. Employers often don't even know what they don't know. With so many regulations to comply with, employers are often overwhelmed. US labor laws have developed throughout American history. They are not all in one place. Employers turn to lawyers to help them follow the law. At the same time, employees want labor laws enforced. They may need help from an employment lawyer to understand what the laws are and either their employer has violated the law. They might turn to an employment lawyer to help them enforce the law when their employer hasn't followed it. Major employment laws in the United States. Some of the most notable employment law in the United States includes the following. Minimum wage laws. The Fair Labor Standards Act of 1938 sets the federal minimum wage. Many states also have minimum wage laws. States can't make a lower minimum wage, but they can make the minimum wage higher than federal law requires. Different types of employees might have special considerations. For example, employers who have employees that earn tips may be able to rely on tips to make up some of the employees' minimum pay. Overtime pay. Employees have the right to overtime pay. The Fair Labor Standards Act says that an employer must pay time and a half for any hours that an hourly employee works over 40 hours per week. While there is no maximum number of hours that an employee can work in a week. The employer must pay overtime for each hour that an employee works over 40 hours in a week. There is no right to overtime for working on a Saturday or Sunday if the employee's total hours stay under 40. There is also no limit to the number of days that an employee can work in a week. Family and medical leave. The United States has no requirement for paid medical leave. However, the Family and Medical Leave Act of 1963 says that large employers must offer up to 12 weeks of unpaid family leave. An employee can use family leave after the birth of a child or after an adoption. They can use it for their own health problems or to care for a spouse, child, or parent who has a serious health condition. Collective bargaining. Employees have a right to organize collective bargaining with an employer. The Clayton Act of 1914, the National Labor Relations Act of 1935, and the Labor Management Reporting and Disclosure Act of 1959. All regulate collective bargaining. If more than 50% of a workforce wants to organize, the company must negotiate it in good faith. Safe working conditions. Employees have a right to safe working conditions. The Occupational Safety and Health Act of 1970 (OSHA) protects employees from forcible hazards. At work, including chemicals, extreme temperature, noise, sanitation, problems and conditions that are likely to cause injuries. Employees can relate against an employee for exercising their rights under OSHA. Employers can't discriminate based on protected characteristics. Employers must be careful to avoid discrimination against employees. They may not discriminate on the basis of race, color, religion, sex, or national origin. The Civil Rights Act of 1964 prevents an employer from discriminating based on these qualifications in both the hiring process. And when making a decision about a dismissal. There are some expectations that employment lawyers should be aware of. For example, casting directors are able to make decisions that are consistent with their creative vision. Employers also can't discriminate on the basis of age. The Age Discrimination in Employment Act of 1967 says that employers can't discriminate against older employees when it's time to decide promotions, compensation, and termination of employment. Similarly, employers can't discriminate against people with disabilities. The employee must be able to fulfill the essential duties of the job, but they can have reasonable accommodations. Civil rights considerations. Employers have First Amendment rights. However, employers have a right to go about their business without interference from employees. For example, in Pickering v. Board of Education 1968, a school wrongfully terminated a teacher for criticizing the school board. However, in Koenig v. Myers 1983, the court said that it was okay to fire a disgruntled employee for circulating a questionnaire on management practices. Civil rights also protect an employee's right to privacy. Employers have a right to privacy in their own handbags and even in private telephone conversations. However, there is no right to privacy on employer-owned electronic devices. Thanks for watching.